How does the enforceability of ASI against domestic non-arbitrability rules affect their overall effectiveness? And finally, what factors should national courts consider in enforcing a foreign ASI that may conflict with national public policy, and how do these considerations impact the practical effectiveness of the injunction? With that, I am excited to finally open the 6th Trilegal International Arbitration Conference 2025. I look forward to the rich discussions ahead.
Thank you, Malavika. Thank you for that introduction and giving a brief of the concept note for today's discussion. I must begin with an important caveat here because, of course, as Malavika mentioned, anti-suit injunction is an important and dynamic area of private international law and international commercial arbitration. And the panelists, we are also mindful of the fact that anti-suit injunction is a contentious issue for your moot proposition. So the caveat is whatever we say, discuss, and argue here is not going to be taken as your pleadings or arguments for the moot court competitions today and tomorrow, right? So with that caveat, let me thank my panelists. So Sahana and I have curated some questions for the panelists. So the idea, what we've discussed is it is going to be a free-flowing discussion, but to start off and to moderate the entire exploration of this topic, anti-suit injunctions, we will pose some questions, both theoretical and practical jurisdictional questions to the panelists. So after the discussion, we will also have hopefully some time for a Q&A session at the end of the discussion, maybe for 15-20 minutes to take some questions from the audience. All right, so let me start off with a general principle or fundamental questions just to set the context for discussion on the idea of anti-suit injunction. And this can be addressed by any of the panelists. Maybe I request Ganesh to start with. So there are two conflicting principles when you think of anti-suit injunctions. Anti-suit injunction is generally seen as, when the context of international arbitration is seen as a tool for respecting the party autonomy, respecting the arbitration agreement made between the parties, but it also poses a risk of interfering with the judicial sovereignty. So the important question here is, how do you balance these two conflicting principles of judicial sovereignty versus respecting party autonomy?
Thank you, Professor Hari, Professor Anna, Steffi, Luke, and Manini, and all you young law students. Before I answer Professor Hari's question, maybe you should pardon me if I take a minute to diverge from the topic. When I see all you young students here, it takes me back to 1992, when I came to this law school as a fourth-year law student from Madras Law College for something called a law reform competition. All right? This is how many years back? 33 years back, right? So it's very nostalgic. I think so much has changed. Of course, I've been last time I was here was to judge an Afro-Asian moot in 1997. But then everything seems to have changed, and thanks so much. In fact, when I was told that I should, when I was invited to come here in person, I did a course on ADR when I lectured a couple of years back, but that was completely online because it was during the pandemic years. It's great to be back, and congratulations to all of you for coming for this moot. Arbitration is a very important area of practice, especially international arbitration. And of course, as Professor Hari said, this topic has some integrate connection to your moot problem. So even if something we say here, and you're going to argue that before any of us who may judge, we may exactly say the opposite to you, because as lawyers, you can argue on both the sides. So now coming back to the question that Professor Hari posted as to the kind of dichotomy on one side between party autonomy as to principles of arbitration, where you can get an anti-suit injunction, and of course, looking at the sovereignty of courts. First, when you see ASI, we are all from India, right? How many of you have been to any like Taj Mahal or any of those ancient places? I mean, have you been to any place in your city which is you've been, right? Or to any other big old temple? You would have seen the board ASI, Archaeological Survey of India, right? What does ASI do in India? Anything which is a protected monument under the Protected Monuments Act, right? The Archaeological Survey of India basically kind of protects these monuments, and it's also a continuous kind of survey it does, and it makes sure that our heritage, the culture, is not spoiled by development, and these have to be maintained. Similarly, one of the tools, ASI, anti-suit injunction, helps maintain the commercial culture that when there is an arbitration agreement between the parties, you should respect party autonomy. And if somebody oversteps that and goes to a court in violation of this arbitration agreement, you should be able to get an order from an appropriate forum, an anti-suit injunction in favor of arbitration. So we are talking about anti-suit injunction in the context of international commercial arbitration. So now the question comes, which is the forum that would grant it? We have several other questions. I think there are some excellent panelists here. A very learned professor from Australia will be speaking to us as well, who's also now dabbling into civil law, which I just saw during our conversation. But what I would think you should keep as a base is that when there is an arbitration agreement, you have to go for arbitration. Because when I talk from an Indian angle, I'll be going into the provisions of our Arbitration Act, which has provisions for this. But for the start, I would say that yes, on one side, there is a power given to court, if at all there is a power. Whether Indian courts have the power or not, we'll discuss later. But if there is a suit commenced, then you have an arbitration clause, you need to have some kind of a remedy by go and ask a court for an injunction. Whether you can go to the tribunal, that's another question as well, which will be answered also. So I think there is, in my view, I don't think you're going to be interfering with the sovereignty of some other court, right? Because you are giving this injunction to the party. Actually, this order that the court gives, or the arbitral tribunal in some countries can give, is in the form of an order to the party, restraining the party from going to a particular court or continuing with this. So you're not telling that court, hey, you stop hearing this case. You're telling the party you cannot go to that court. Whether it will be enforceable, all that is questions which we will discuss during the course of that. Luke, may
I thank you very much, and first of all, many thanks for inviting me back to National Law School. I was here 10 years ago because a valued MOU partner with Sydney Law School, and particularly to professors here and students for arranging this terrific moot competition related conference, and of course the main sponsors including Tri-Legal. Now, it's quite interesting because we'll talk more about this, but the common law jurisdictions have gone down this track of coming round and expanding this idea of anti-suit injunctions, ASIs, and generally have seen it in a positive light. And I think that the two main advantages are that it upholds party autonomy in their choice of the forum, in our case, an arbitration forum, against an overreaching foreign court jurisdiction, as it seemed. And initially it was actually the US courts were seen to take a lot of jurisdiction compared to even other common law courts. And so the English courts started issuing anti-suit injunctions against American plaintiffs. But for quite a while, the Russian commercial court has also been exercising jurisdiction, and of course it's the background, not really hidden in your moot problem. This has come back intensified, but actually the Russian courts have quite a long history. So on the one hand, it's overreaching foreign court jurisdiction, and on the other, and the second scenario where it's useful is where the courts are not necessarily, or the legislatures are not exerting strong jurisdiction, but it's a problem of judicial dysfunction. Because normally in the international arbitration architecture, say under the New York Convention, if a foreign party starts litigation in disregard of an arbitration clause, you apply for a stay of proceedings, right? But what if that jurisdiction has a lot of delays? Just to give an example, there are some countries where courts have more delays than others. Or, thinking of now Indonesia, what if there's quite a bit of judicial corruption, right? Why should, you have to defend yourself to get a stay of proceedings to uphold your arbitration agreement in that foreign jurisdiction? So, there are those major advantages in developing this anti-suit injunction relief. But on the other hand, as Professor Hari has mentioned, it interferes with foreign judicial and legislative sovereignty, right? So, and it gets awkward, particularly, say, in the second category of cases, where maybe stereotypes and lack of information about so-called judicial dysfunction in those foreign countries is at play. And so I went back and did a little bit of research on this topic. And if you go back 20 years ago, you had those in the common law tradition, very esteemed jurists like Stephen Schwebel, was a ICJ judge for 20 years from America originally, who thought the growth of the anti-suit injunction, disrupting comity and showing, if you like, some disrespect not only for foreign courts but for the international arbitration and international disputes resolution system architecture, is a bad way to go. And you might say, well, he's American, so of course you'd take that view, because the English courts were starting to issue these injunctions against American parties. But also Christopher Greenwood, another ICJ judge, who's British, he also raised some questions about this remedy in 2005. But it's really taken off. I did find a really interesting article written by a Russian lawyer who'd done the MIDS program in Geneva, Masters of International Dispute Settlement, that I've also taught into. And maybe because she can see both sides, she has a very good article in 2015 in the Journal of International Arbitration. And she says some of the reasons for being still concerned at that stage about anti-suit injunctions are, first of all, the competence of courts. Like, you've all studied arbitration, you know about the competence principle for arbitration, right? And you're all nodding and you think, well, that has a lot of merit and so on. Well, what about the competence of courts to determine their own jurisdiction? Secondly, what about access to justice? We know the elephant in the room often is arbitration is also getting very expensive and time consuming. So, what's wrong in principle with a sovereign state enacting legislation saying, well, come to the courts, which might actually, for some types of cases, be more efficient, especially for their own nationals. And thirdly, what about this broader idea of comity and trust in each other's courts? Because there's this sort of epistemic community of judges around the world, and not just now in the common law tradition, say between Indian judges and British judges and Australian judges and Singaporean judges, but even in the civil law jurisdictions of countries of all stages of development, even different political systems, but the judges are sort of talking to each other and building up trust in each other and so on. And adding in this anti-suit injunction remedy really can disrupt that. And finally, another point she makes is the effectiveness of these remedies, and we'll talk more about this later, this sort of relief. Are there any other sorts of mechanisms that could achieve similar objectives and help the party that's trying to get the forum, the arbitration forum, to proceed with the case without disruption by foreign litigation disregarding that, allegedly? Well, yes, there are. I mean, courts are issuing damages for breach of an arbitration agreement. Like, there's a recent Hong Kong case on that point. And there have been other earlier examples, even tribunals issuing damages for breaching an arbitration agreement. And finally, you also could, in terms of effectiveness, lead to retaliation by the courts that are indirectly injuncted. Yes, it's against the party, but it's, you know, the courts of that jurisdiction can take offence and retaliate in various ways. And finally, you can get into the risk of non-enforceability, which is also another topic we talk about. So I found that useful because otherwise, if we look at contemporary literature and developments, the trend has been towards more and more countries issuing more and more anti-suit injunctions against exclusive forum selection clauses, but now arbitration agreements. And we've come to think that this is all perfectly normal. But actually, there are these tensions between different principles, different approaches, and tensions, dare I say it, between common law and civil law countries that we might get into later. Thank you.
Steffi, maybe have your views on the conflict between the respect to party autonomy, arbitration agreement versus so-called judicial sovereignty. We understand that it is not, as Ganesh mentioned, it is not a direct attack on the judicial sovereignty, but still, as Luke just mentioned, there could be some offences taken by the court itself.
Thank you, Professor Hari. Firstly, good afternoon, everyone. Thank you for having me on this panel. And on behalf of SIAC, if I may just say, we are very proud and delighted to be a part of this conference and also the mood that's ongoing. The participants here, all the very best. I understand that you've had some rounds already and you'd have some advanced rounds tomorrow. So good luck for that. Coming back to the question, I do agree with the panelists here that anti-suit injunctions, they're a bit of a delicate space, if I may call it, a bit of a gray area. And I say it because I don't see it to be completely black or completely white. I mean, of course, its justification hinges on the procedural efficiency of an arbitral proceeding, right? But then there's also certain instances, certain scenarios where they're susceptible to judicial intrusiveness, as Professor Luke was saying, that some courts may take offense to it because it goes against judicial sovereignty for some in certain jurisdictions, right? So for me, it is ultimately about upholding the principle of pacta sunt servanda. The agreement must be kept. But certain times when there are two parties that are getting into a contract, that are entering into a contract and have the arbitration clause or the dispute resolution clause, the parties would not know what kind of disputes you may end up having during the contract, at the end of the contract, during the process there, right? So anti-suit injunctions are good because there could be some recalcitrant respondents who may want to delay the proceedings. So it's always good to have this option. But sometimes it may also be a bit black because there are certain claims that cannot be arbitrable at all. It could be a statutory claim or a regulatory claim, and a claimant may not always want to go to a foreign jurisdiction to get these claims settled, right? So for me, it's a bit of a gray area. It depends on the circumstances of the case, but it's definitely a very important tool to have in your tool shed when you're starting a dispute.
Thanks, Steffi. To Manani, so how do you see, what do you think about how whatever be the forum, arbitral tribunal or a national court, how should they balance these two competing interests?
Hello, thank you for having me, and I share my panelists' excitement about being among students, especially in a university such as this, because I'm sure every law student at some point has either had an engagement with the National Law School in Bangalore or wanted to study here in some capacity. It has become sort of the center around which the legal field has evolved for many, many years now. So I'm very happy to be back here. On the question of how these competing concerns should be balanced, I just have 2 points because everything's already been said by the panelists before. I think the first thing to consider is what is the effectiveness of the remedy that you're seeking, and that is specific to any particular factual circumstance. So, if you're approaching a court for an anti-suit injunction, what is the likelihood that that injunction will be respected and will not lead to a spiraling torpedo of litigation in multiple jurisdictions? So that really, for me, is the central concern around sovereignty versus the arbitral integrity, and it becomes more pronounced in the context of courts which have tenuous links to the arbitration. It is easier to make a case for an anti-suit injunction where the court can be recognized as the natural forum for relief because there is enough nexus to the dispute, to the parties, to the assets of the parties, so that there is a reasonable probability that the injunction will be enforced and respected. But the further you go from that central concept, the more tenuous the justification for the anti-suit injunction becomes, and the less likely that it's going to be effective in protecting the arbitral process. And so, for me, the balance that was spoken of before really lies in in having a strategy which uh, which protects the outcome of the arbitration without compromising the other fundamental principles around which access to justice is based. And the dispute can swing either way. It's all right, and we all know that under the New York Convention, that is really the root justification for ASIs in the first place. That courts and contracting states have taken the obligation to defer matters to arbitration when there is an arbitration agreement. And it is all right that you have to protect that, and you can always make an argument in court that the agreement should be protected. But then, on the other side of the pendulum is the issue of access to justice and respecting the laws to which the parties have agreed. So that could be, for example, if you approach a court for an anti-suit injunction where the seat of the arbitration is in a jurisdiction which doesn't really recognize those injunctions or issue them regularly, you are going very far from the central concept of nexus. And so in that circumstance, I don't think the ASI is effective. But if the central idea of protecting the arbitration is rooted in a place, in a seat of arbitration which recognizes ASIs, for example, English courts and French courts, then you have a reasonably good case of trumping the argument on access to justice and saying, well, our agreement should be protected. And so similarly, issues of public policy, issues of arbitrability, they have to be viewed from from the perspective not only of the court that you're approaching, but also the court of the seat and the court of potential enforcement, where you're going to take the ASI and say, well, because of this ASI, you have to stall the suit that is impending in this court. So it is a matrix, and I think the balance shifts on the basis of where that matrix leads you in terms of the factors that are connected to the arbitration. Yeah.
Thank you to all the panelists for sharing that conceptual framework around which ASIs work, and for also touching upon these competing concerns. I think what Manini just said might be a great segue into a question that I have for all of the panelists, which is what might be the best forum to approach? Is it a court, or is it an arbitral tribunal that you approach if you have an ASI that you want? Of course, there are concerns regarding enforceability, as you just spoke of, but also
possibly concerns touching upon competence principles. So maybe I can have you start off this discussion.
Thank you for that. And you're right, it just is a leading sort of concept from what I've just discussed. So again, it will depend on a multitude of things that apply to the facts of the case, uh, which includes the arbitration agreement, the law of the seat, the applicable rules of arbitration, the court which you're approaching for the anti-suit injunction, and the court which is likely to be the forum where the suit is going to be instituted. So, de- depending on these factors, you will choose between the arbitral tribunal and the court that you approach, because it is possible, for example, that the applicable institutional rules themselves are permissive, and expressly or impliedly permit a tribunal to issue such injunctions. And the seat, the law of the seat, if it is a prominent seat and a seat where courts have routinely upheld the arbitration agreement or the barter between the parties, for example, Singapore or England, then the courts of the seat are also likely to support the idea of such injunctions in favor of arbitration. So if that is the factual matrix, then I think it's okay for a party to approach a tribunal with the expectation that they will be protected. But if that is not the likely scenario, and you have a problem in terms of the rules or in terms of the arbitration agreement, then you're looking at a very different remedy and a very different forum. And then you probably want to, as Luke had also mentioned earlier, go to a court which will protect you because you're not confident that, for example, the courts of the seat might. And so I think it's a balance which is based on the factual matrix.
Maybe you could have Ganesh go next.
See, there are a few things we need to kind of first dissect on what the subtopics on this. Whether you go to court, you want to go to arbitral tribunal. First, as Manini rightly pointed out, first thing is you need to look at the contract between the parties. What do they say? Does the arbitration clause provide for an exclusive jurisdiction court to any particular court, or it does not have that clause? That's the first thing you need to look at. There's an exclusive jurisdiction clause in addition to the arbitration clause. It says, let us say, for all applications, you go to the courts in Bangalore. That is the contract so says. And there's an express agreement that perhaps you'll have to try that court first. It also depends on when you're going to institute this application for an anti-suit injunction. Typically, it is done once when a party commences the suit. It's not like an injunction restraining somebody from dissipating an asset, an interim injunction situation, right? Where you think that if somebody is going to do something, you want an urgent injunction, you can go to court and get that injunction. And in an arbitration, you can also get, in India, for example, under Section 9, you can go to the court even before you commence an arbitration, you can get an interim measure of protection, but you need to commence an arbitration within 90 days thereafter. And under the SIAC rules, I'm sure the new rules, Steffi might explain that you have an option, something similar to a Section 9, where you can go pre-arbitration to the court to get an interim order. But when it comes to anti-suit injunction, typically I would think that you would do it when somebody institutes the suit. And then you would go to a court of competent jurisdiction, or you could go to the arbitral tribunal as well. But when you go to the arbitral tribunal, this tribunal would consider this as an application for interim measure of protection. If it is the Indian Act, it's something like a Section 17 application. If it's the SIAC rules or the ICC rules or MCI or MCI rules, there are provisions there which expressly provide for the arbitral tribunal to look at interim measures of protection applications from the parties. And it could be that you may ask the court, the tribunal, to stop or injunct the other party from proceeding with a suit they might have commenced in another court, which is in direct contradiction to party autonomy where they have agreed to an arbitration agreement. I will not delve into the particular sections in our Arbitration Act because there are two things here. I will deal with it when I'm coming to India specifically. I've got quite a lot to say in that. So I would think that best is, in my view, as a practitioner in India, in a common law country, I would think it's ideal to go to a court if you can, because it's an order which you can enforce. And it also depends on where the suit is. If it's outside the country, does the court in India have the power to grant such a injunction? Or if it's in India, do the courts where you want to go and seek an injunction have the power? Like Manini said, it depends on which, so you need to choose. And then again, you need to look back at the agreement. Does it provide for an exclusive jurisdiction clause? So all these things, I think, put together, you need to choose. I think, therefore, it's very important for you to, if you're a client, to engage a proper lawyer to decide this. No, seriously, because otherwise you can't just go to some forum and then, get stuck there. Because they're very, very important. And somebody who understands this area is also extremely important, who does cross-border kind of work is very important. And I think as future practitioners, you need to always remember the first thing you need to look at is what the parties have agreed. The contract, that is the first thing you need to look at. For example, somebody says, principles of natural justice violated in this case. Immediately you cannot say, oh, Supreme Court judgment in Maneka Gandhi versus Union of India. First, what are the facts of the case? What was the alleged natural justice? What was done so that you can allege violation of natural justice? Then you apply the law and case law to that. So look at the contract first. Then other things can follow.
Thank you. So perhaps you can have Professor Luke.
Thank you. Since you're all involved in moot competitions and we've been talking about different factual scenarios, I was thinking this morning that imagine we have a very naughty Australian company that has an iron ore or coal supply contract to India. So I'm the Australian company. Professor Sahana's the buyer, the Indian party. And of course, they've agreed to have the arbitration in Singapore with Xviii and the SIAC rules. The Indian company is upset with the quality of the product from Australia. But the Australian company starts some litigation in Sydney, New South Wales Supreme Court, saying, well, there was some misleading conduct by the Indian party lead up to the contract being signed, and this raises issues of public policy under what was called our Trade Practices Act, now the Australian Consumer Law, even though it applies to business transactions like this as well. If we vary it, there's also, if it was an insurance contract, for example, there is some Australian law that gives primacy to override some party choice of governing law, and by implication, according to one of our early cases, some forum selection clauses. So in that sort of scenario, the Indian party, advised by Indian law firm, might, as he said, go off and seek an injunction from the Indian court, anti-suit injunction against the Australian company, assuming Australian company or their directors and so on have some sort of link with India. But then the Indian lawyer might say, well, what's the average time taken to get this injunction in Delhi court or whatever, or Chennai court? So the advice might be, we'll go to the courts at the seat or go to the SIAC arbitration tribunal, right? So then we get into, assuming the Singaporean courts are quicker, and the substantive law to apply to whether they issue the injunction is broadly similar. So it's just a question of where can we get the injunction quicker? And again, we still have to assume that the Australian company has enough connection to be, if you like, scared of the Singaporean court's injunction. Well, there might be an advantage to at least try to get the SIAC tribunal order rather than going to the Singaporean court, because it might be even quicker. You know, it could be the sort of thing you apply to the emergency arbitrator, or it could be a sort of a small value dispute, and so it's in your expedited arbitration track, so fast track appointment of arbitrators and so on, or it could be even your new simplified, you know, documents only type procedure, which is even faster, right? And that's going to be even quicker than the Singaporean courts, let alone the Indian courts, right? Plus, there's the other potential advantage that the order of the arbitrators seated in Singapore could be actually, in some cases, more enforceable around the world, you know, against, well, it would have to go through the courts in the other countries eventually if it was, you know, contested. But the SIAC or tribunal's order might be enforceable in Australia because it's a revised model law jurisdiction, right? So this is an interim measure, even though it's a foreign-seated arbitration, so Australian courts will implement it. But also other countries that have adopted the revised model law around the world, right? And this might be, particularly in civil law jurisdictions, more effective, say, than, you know, an order from a Singaporean court, right? Now, in my scenario, I don't want to leave anyone out. So, so imagine, you know, that the Indian law might say, oh, well, yes, maybe the Hong Kong courts are even faster or have a even more generous approach. So if Malini is representing Hong Kong here because, say, for some strange reason, the law governing the main contract was Hong Kong law, right? And under, I'm not sure if this is true still, but under Hong Kong law, that then influences the law governing the arbitration agreement. And again, if there's some sort of, or maybe even a bit more connection with Hong Kong, then maybe that's another option. And then just last, not least, well, actually least, because imagine Professor Harishankar is the English court. Do we go to England? Well, the answer there is quite simple, no, right? Because the English courts will say, don't come to us for an anti-suit injunction. We don't want to lead to this proliferation of anti-suit injunctions and lots of work for lawyers advising on where to go for your anti-suit injunction. The English courts have recently said, look, you should really go to the courts at the seat, right? And England's not the seat, Singapore is. So that's maybe a scenario to keep in mind. But to answer the question, I can imagine scenarios where going to the arbitral tribunal could be actually very effective now that we have more and more countries that enforce foreign-seated tribunals interim measures. And efforts are made by some arbitration institutions more than others, better than others, to try to get quick decisions, even quicker than courts in some respects. Thank you.
Thank you, Professor, for that very inclusive example that drove home the point. Maybe I can now come to Steffi, who also works with an institution, and I think you could maybe reflect on how these competing considerations work.
Yeah, thank you, Sahana. Actually, Professor Luke, you've made my answer really simple because I wanted to highlight just one point. You have to choose between a court and a tribunal. I would advise everyone to be a bit strategic. And how do you be strategic? As Ganesh sir said, find a good lawyer, right? Because for me, it is about at what stage of the dispute are you trying to get an anti-suit injunction, right? Let's say a party has started parallel proceedings or the first proceeding in a court somewhere in a different jurisdiction. But you have the arbitration agreement, you have SIAC in the arbitration agreement, you have seat to be the India or Singapore, something somewhere here, right? Now, it depends. If you've not already had the tribunal already constituted, if you don't have the notice of arbitration, the tribunal already constituted, there is jurisprudence which says that sometimes a court may look at not giving an anti-suit injunction if the parallel proceedings are later in the stage, right? If they're in the advanced stages, a court may look to not give an anti-suit injunction. So essentially, for then your party, it gets watered down. You may not get an anti-suit, right? So would you want to wait for a tribunal to be constituted, which could take somewhere from a month or 2 months, right? Would you want to wait till then and then furnish an application before an arbitral tribunal? Maybe not. At that point, strategically, it would be better for you to go before the court of the seat and get an ASI from there. But let's say if your arbitral tribunal has already been constituted for reasons of confidentiality or because the arbitral tribunal members would be better versed or well versed with the facts of the case, you may want to bring an ASI application before the tribunal. As Professor Luke said, now it becomes even better because there are so many jurisdictions that have started giving teeth to these kinds of interim orders, interim awards from the tribunals. So essentially, it would then depend on what stage of the proceeding. Let's say, let me take a step back even, where if you are at the start of the case, where the notice of arbitration has not been given yet or the tribunal has not been constituted yet, then it depends on whether the clause in the arbitral, in the contract has institutional or ad hoc. Because, I mean, I'm from an institution, so of course, institutional flag there. But if you do not have an institution or an institution, let's say just like SIAC, then ad hoc may even take longer. The cases may just get delayed on and on for either you have to go to courts for appointment of the tribunal or you may have to go to courts for the Section 17 applications. It just takes longer there. Let's say if you have an institutional institution mentioned in your contract, like SIAC, even if you do not have the tribunal constituted, you can, as Ganesha has said, go under an emergency arbitration. You can have the tribunal appointed within one day of your application, and you can have the order within 14 days. Now, a 14-day ASI versus a few weeks or a couple of months from a court, right? So these are some of the strategic requirements that you may have to think for in terms of what suits your party the best. At the end of the day, both courts and arbitral tribunals would work, depending on, of course, as Manini said, depending on the law of the seat, the law of the arbitration agreement. But for me, it depends on what stage of the dispute you are at. I think that would be my answer.
Thank you, Steffi. Now, coming back to a point that Mr. Ganesh referred to, particularly on the application of Section 9 versus Section 17 in the context of grant of interim measures. Assuming that court is considered as a better forum to grant anti-suit injunction, and different jurisdictions have different approaches with respect to how courts look at this issue. And in India particularly, we have, I think, some jurisprudence on the issuance of anti-suit injunction, not just in the context of international arbitration. There are other conflict of laws issues and the principles evolved from Indian court jurisprudence on ASIs. But because you've also referred to a set of case laws in India with respect to anti-suit injunctions, specifically in the context of international commercial arbitration. So we were wondering if you could enlighten us on those aspects of anti-suit injunctions from India.
So here there are two things. One, you get an anti-suit injunction from an Indian court restraining the other party from continuing another suit where there's no arbitration involved, right? That is one angle of anti-suit injunction. The other is that there is an arbitration clause. Of course, here we are all thinking about the arbitration clause, but when it comes to a general anti-suit injunction in India, we have a provision in our Specific Relief Act, the Section 41, which expressly prohibits an injunction from being granted. It says an injunction cannot be granted to restrain somebody from proceeding with a suit or an action unless it is to prevent multiplicity of proceedings. That is one. Two, it has to be a suit which is instituted in a court subordinate to the court in which you're seeking the anti-suit injunction. So this is what Section 41 of the Specific Relief Act provides. In fact, there are case laws in India, both the Modi Entertainment case as well as the Delhi High Court in the Horlicks, versus Haynes case. They've recognized that in the domestic context, courts would be very slow to grant an anti-suit injunction. This is I'm not talking about the arbitration angle. I'm talking about the general anti-suit injunction against institution of a suit. Unless, of course, when discretion is there in domestic context, it's tough. But when it's instituted outside the country, then you look at The court has the discretion. The decision says you have the discretion, you can look at it. Of course, you need to look at comity of courts in other nations, whether you can grant it. If you do not grant it, whether there's going to be irreparable loss and grave injustice caused to this party. And the Indian courts would first also look at whether the company or the person who's coming before the court, whether the court has jurisdiction over that person. That's very important. You need to have personal jurisdiction over the party before it. So these are the things that the court would look at when granting an injunction. So there are a lot of case laws, not lot, very few actually. I would say Modi Entertainment is one case. And in fact, in 1970, the Supreme Court case in one of the matters granted a anti-suit injunction against a party from proceeding with a suit in Russia, in Moscow. So I would look at Section 41 of the Specific Relief Act in the context of a non-arbitration clause scenario. When it comes to an arbitration clause, it's very clear, right? When you have an arbitration clause in the contract, and let us say the other party goes to court and commences an action, a civil suit, you can go to court under Section 8 or any judicial forum for that matter. I think you should all look at Section 8 of our Act, which I think will be very useful, not only for today, but for your future practice as well. What does it say? It says, you all have the Arbitration Act with you? Soft copy, right? Okay, power to refer parties to arbitration where there is an arbitration agreement. A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, there's no discretion to the court, it's mandatory. If a party to the arbitration agreement or any person claiming through or under him so applies not later than the date of submitting his first statement on the substance of the dispute. We have followed the model law here, institutional model law. Then notwithstanding whatever, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. So I think the court, when it is faced with an application where there's an arbitration clause, but it has to, the other party has to bring this application under 8 before that party takes a first step in the merits of the dispute. Typically, it would say before you file your statement of defense, or in Indian context, we call it the written statement. There's a plaint. Before you file a written statement, you bring this application and say, hey, there's this arbitration clause. How could you have this suit? So therefore, the court has to refer this. What the court can do, it cannot go into a complete merits-based hearing. All this is settled with the 2015 amendment. Prima facie, is there an arbitration clause is going to work? Send it to the tribunal. If there's any issue of jurisdiction, raise it before the tribunal. The tribunal has the power to decide whether it has jurisdiction or not to hear the case. This is in the context where the arbitration clause provides for arbitration seated in India. Whether it's a domestic arbitration in India or an international arbitration seated in India, you go to the Indian courts. But what if a suit is commenced here and you have an arbitration clause with arbitration in New Zealand, right? Can that party, one party is Indian, the other party is from New Zealand, can that party come to the Indian courts and say, hey, this is supposed to be decided in Auckland, how can you commence a suit in Delhi? Can you do it? Yes, you can. Under Section 45 of our Act, this is Part 2 of our Arbitration Conciliation Act, which effectively ratifies the New York Convention. New York Convention is the Convention on Recognition and Enforcement of Foreign Arbitral Awards, which was opened for signature in 1958. Before that, you had Geneva Convention. In fact, if you look at our Act, you have provisions which give effect both to New York Convention as well as Geneva Convention. So under 45 of our Act, similarly, you can go to the court and say there is an arbitration clause with the seat outside. So this is an arbitration agreement as per the New York Convention. So please refer the parties to arbitration. Under Section 45, you can similarly go to court like Section 8. That's for arbitration seated outside. Similarly, with the Geneva Convention, which I don't think any of us practically really use it these days, we have been recommending to the ministry that they should probably think of dropping it, because all those countries are parties now to the New York Convention, but for some reasons they've kept it. Maybe one or two countries may be there, I don't know. Under Section 54, if the Geneva Convention signatory, you can still go to the court and say this is a country which is a party to this convention. And you can find these conventions in our Arbitration Act, Schedule 2, provides for New York Convention. Schedule 3 gives the protocol, and then you have Schedule 1 is New York Convention. Schedule 2 is protocol for arbitration agreements. Schedule 3 is for foreign awards Geneva Convention. So these Geneva Convention and protocol were done pre-United Nations. It was under the League of Nations. So it was, the precursor to the UN, but this one is after, so 1958. And India ratified the Geneva Convention in the 1930s and the New York Convention 1961. But all this is academic now because we have the 1996 Act which encompasses all this, and we have made amendments to that, and further amendments have also been proposed. So when there is an arbitration scenario, absolutely there's not a problem. The court has to grant. It is not in the form of an injunction, that's not used here. It has to refer the parties to arbitration. So therefore it is a little different, but indirectly it is restraining the party, right? So therefore there are case laws that do recognize anti-suit injunction in a very rare circumstances, even if it is not an arbitration scenario. But if it's an arbitration scenario, you go under Section 8 if it's domestic, under 45 if the arbitration seated outside India.
Thank you, Mr. Chandru. Maybe I'll get Manini into this question right now. So previously, when the UK, when England, when UK was part of the EU, we had several cases from EU which spoke of anti-suit injunctions and the frameworks that would have to be followed by courts within the EU. But post-Brexit, I think British courts have had their ups and downs with anti-suit injunctions. So perhaps you could reflect on your experience with the UK as well as with India, but particularly after Brexit, if there's been a difference in the way in which British courts have or English courts have looked at anti-suit injunctions and whether they've looked at it more favorably since Brexit.
So I think you're quite right in terms of the exit from the EU having an impact on the way English courts approach these issues now. One, of course, because the Brussels regime was very particular in general about conferring each national court the jurisdiction to look at questions of its own jurisdiction. And so it would have been very difficult and arguably prohibitive in the EU regime to actually issue anti-suit injunctions interstate member states. But ever since then, the UK has brought about amendments to its national law, particularly on civil procedure, to re-establish automatic jurisdiction in matters where, in contracts where English clauses are contained. So there is that shift, but there is also the other shift, which was briefly hinted at earlier on in the panel, which is one is the fact that there are some jurisdictions that tend to exercise this sort of extraterritorial authority, whether it is the United States and now Russia as well in some aspects because of the sanction regime. The other is that there is a sort of race to establishing each country as the center of commercial disputes. And I do see that, for example, the decisions that are coming out of England sort of reinforce that way of thinking. And in that, I think the English courts are different from Indian courts because while it is permissible, as Ganesh sir just said, to have anti-suit injunctions issued in India, the Indian courts are very careful about uh, overstepping their authority and very mindful of comity. And that's not surprising given that our entire view of international affairs historically has also been aligned with that philosophy of, live and let live. So we have that very strongly, even in the decisions that Ganesh sir mentioned, whether it is Modi or it is the BCCI decision, which was the Delhi High Court decision on the issue. In fact, in BCCI, they specifically said that while this is permissible, one has to consider a strong justification for issuing an anti-suit injunction, which has to be based on uh, the ability to exercise a personal jurisdiction, and also on the eventual enforceability of that anti-suit injunction. So if it is a party which is foreign and which resides elsewhere and is in any event going to seek remedy there, and the arbitration is also seated outside of the country, then those links are very tenuous. Uh, so our courts have always had that view. Whereas in English courts, if you see whether it is the UniCredit decision or the Magomedov decision, you see that once they find that they have the authority over the dispute, they need strong reasons not to grant the injunction. So I think that there is a difference in approach here, and in my humble estimation, the Indian approach is way better. Because the entire system of international commercial arbitration is based on the recognition of sovereignty of different nations and a comity amongst nations in enforcing commercial contracts. Once you exceed that, for example, in the Magomedov decision, I mean, just think about the anti-suit injunction and then the anti-anti-suit injunction and then the anti-enforcement injunction. It just went on. And even in UniCredit, I mean, we look at the main decision, that's fine. But then subsequently, the Court of Appeal in that matter had to modify the anti-suit injunction because of the problems because of retaliation and the problems around enforcement. So, I mean, why put yourself in that situation, as a sovereign court? So I do think that we're comparatively better off here in India.
Just taking cue for maybe, I mean, I'm coming to Professor Luke only. I don't know. So one case that comes to my mind, because when Professor Sahana asked this question about what happened in Britain or in the UK post Brexit, so the case of West Angers. So I was wondering if Professor Luke could throw light on that and how things have changed in the UK and other jurisdictions, maybe in Australia, or is West Anchor still a good law? Also, my specific question to you is, you've also referred to, I think, in the context of a journal article, the competence of the courts, as opposed to the negative competence that we know in the context of arbitration, where courts are not supposed to get into questions, and also the issuance of anti-suit injunctions make more sense, the negative competence concept. But when you say that courts can actually exercise their competence and issue an anti-suit injunction. So my question is very simple. How do you look at this two contradictory competence equations, and is that playing a role in Australia or in jurisdiction that you are aware of?
A lot of questions and room for thought there, but quickly on the last one, I was just channeling this argument by Olga, 2015, Journal of International Arbitration article, which I thought summarized the pros and cons. And actually, the subtitle is that ASIs are a sort of a necessary evil in many situations. So that's where she comes down on this question. But one of the objections to them is that, just as we allow tribunals to rule on their own jurisdictions, at least initially, subject to review by state courts or enforcement courts, we expect courts to be able to have the authority to rule on their own jurisdiction, and if it's given by clear enough legislation, and even if we don't agree with the legislature, I mean, that's their sovereign right. Yeah, but and I think, yeah. So, but getting back to the other question about West Tankers. So, for benefit of those in the room or on the live stream recording, so this was a 2009 decision of the European Court, saying that English courts couldn't issue ASIs to try to restrain litigation in other then EU member state courts, right? And And the idea was, there was EU law, which was very specific about creating a regime for courts in the member states taking jurisdiction, giving awards, having them recognised easily in other member states, right? And going outside this structured regime to let not just English courts, but any court in the dozens of EU member states start issuing injunctions against other courts would totally undermine the rationale of this regime, right? And then people got thinking, oh no, what happens if you get an English-seated arbitral tribunal that issues a measure to stop a party, proceeding with a litigation in another then EU member state? And the European court said, no, that's okay, because that's arbitration. The West Tankers case is limited to courts in, say, England or other EU member states interfering with, purporting to influence jurisdiction taken by other EU member states. Now, when the West Tankers case came out in 2009, a few years later, there was a then federal court judge in Australia who said, oh, here's a great opportunity for Australia, right? Which just encouraged everyone, like from India or wherever, to flood to Australian courts, and we'll happily issue. We didn't quite say that, but Justice Rera said, this could be our opportunity. This didn't happen. Maybe we're not as good as marketing ourselves as some other countries. Maybe, just as we didn't market the fact that our High Court had let third-party litigation funders go wild, like long before other countries started, even more restrictive regimes. But I think it's primarily because our law did provide for them, but it came out of some equitable, jurisdiction and principles, but more importantly, which created some restrictions I'll talk about briefly. But it also, more importantly, there weren't enough cases where there was enough of an Australian connection, because we still don't get enough parties that say, well, we want to have the seat in Australia, right? Which is an obvious connection for an Australian court to issue the anti-suit injunction to prevent foreign proceedings in disregard of a pretty clear arbitration clause. Or other links, the law applicable to the arbitration agreement, maybe even the main contract, or even just not enough parties, foreign parties with enough sort of presence in Australia to attract the personal jurisdiction. And even in personam jurisdiction, even as established, the court might exercise discretion and say, look, on a forum non-convenience basis, we shouldn't keep going with this case and issue the requested injunction. Even though Australia has actually a more, if you like, parochial view of the forum non-convenience doctrine. I mean, will only an Australian court with prima facie jurisdiction won't lose it or decline it unless it's a clearly inappropriate forum, which is a more parochial test. But I just don't think there were enough factual scenarios to trigger a lot of a flood of applications. So we don't have a lot of case law, but we have enough precedents and cases from the late 90s, from our highest courts and other courts, which are in the vein of those early English courts, like the Angelic Grace in 1995, which said, look, as part of the sort of equitable jurisdiction and concept, a court can issue an injunction against a person that stops them proceeding in another court. I mean, it goes right back to the old days of, equity courts and trying to prevent injustice in common law courts and so on in the old English days and so on. But this concept is recognized in modern fused jurisdictions of common law and equity. But the original idea was this was an exceptional remedy, right? And the English courts in the Angelic Grace case and subsequent cases have said, well, in the case of, a clear enough arbitration clause or an exclusive court choice clause, it shouldn't be exceptional. It should be the reverse, as you say, right? And you should basically get the injunction unless there are strong grounds for not giving the injunction because of party autonomy. You've agreed to this. So they developed this equitable jurisdiction. But still, in Australia, we'd say, even if it's no longer exceptional, some of the features of equitable jurisdiction still apply. So it's discretionary, and you can make all sorts of arguments. For example, you don't have to apply for a stay of proceedings in the other court, foreign court, for example. But if you have, that's a good sign that you should issue the injunction. It's just you've applied for the stay of proceedings, but it's delayed, or the courts are corrupt overseas, and so now you're approaching the court. Plus you're applying. The arbitration clause is pretty clear, right, on a prima facie test. So that's favouring discretion being exercised to issue the ASI from the Australian court. You've applied in a timely manner, right? And of course you can show that it's effective because there's a in personam jurisdiction. Plus there's no forum non-convenience problem, so we should issue the injunction. So in terms of strict law, I think even though it's discretionary, I think if Australian courts are in line with the trend, an instinct of the English courts to sort of issue these injunctions more than they did up until the mid-1990s. But I mean, I do think the English courts are maybe backtracking a little bit, right? With this recent case where they said, well, really it should be primarily the seats of the courts of the seat, because after all, if it's all about respecting party autonomy, well, if they've agreed to arbitration, and usually that means they've expressly chosen a seat, then that should, as much as possible, should be run through the seat courts, including the issuing anti-suit injunctions. So maybe the English are backtracking a bit because there have been so many applications, particularly in recent years with the latest Russian sanctions regimes, in the English courts, and even the English courts are starting to think, oh, well, there has to be some sort of limit to this. Otherwise, we're going to get lawyers applying for, in the same case, to Hong Kong, Australia, Singapore, India, other courts, and it'll be chaos. So maybe there's a bit of a backlash. Well, not backlash, but just a bit of caution now in the English courts. But I'm no expert.
Thank you. And so, Steffi, how do arbitral institutions look at anti-suit injunctions? So you represent the SIAC. Are there any ways in which parallel litigations can be discouraged through institutional rules or in other ways in which the administrating institution has come up with procedures?
Thank you, Professor. At the risk of repeating myself, and I am aware of the fact that some of the answers that I give here may be useful for argument in the moot tomorrow, but to answer the question, yes, and I'm speaking about SIC rules in particular here, is we definitely have some checks and balances in place in our rules to make sure that parallel proceedings are discouraged. We don't have anything explicit in the rules, but we have, let's say in the 2025 rules, we have Rule 45.1 of the SIC 2025 rules, which we talk about interim relief or injunction. By the way, a note here, if you argue this, I'm going to argue against you tomorrow. So, I mean, of course you should. So Rule 45, under the 2016 rule, I think it was Rule 30.1, that has given the power to the tribunal to give an interim relief or an injunction. Under the 2025 rules, however, there's something that I'm really interested about. We haven't had the opportunity to see that case yet, but we have a new procedure called preliminary determination, which is Rule 46. And I think an anti-suit injunction could be a good case for a determination before a tribunal to preliminary determine whether we get an anti-suit injunction and then move on with the rest of the case to save time and cost. But apart from the rules, I would say as an institution, we are also very aware of the fact that ultimately an ASI is a tool for procedural efficiency. And for us to then, it is incumbent on us to make sure that the tribunal or the the different rules are in place to make sure that an ASI can be given effectively. It could be, as I said, Rule 45.1, but it could also be to be procedurally efficient ourselves. We make sure that the tribunal is in place at the right time within the timeline that's provided under the rules. We make sure that the tribunal is equipped enough with additional powers to make sure that he or she has the room to move around and give these kinds of interim relief or injunction. Another option could be an emergency arbitration where, as Ganesh sir was saying, something with, under the 2025 rules, now you can apply for an EA application before the notice of arbitration, right? So if you do not have an arbitral tribunal in place and you do not want to go to the courts for an ASI and you have an institution such as SIAC in your clause, then an EA application even before the notice of arbitration would be a good strategic way to go about it. So these are some of the ways which we make sure that the procedural efficiency of the entire arbitration goes smoothly. But apart from that, I mean, when I'd also seen these questions, I'd also gone back and seen some of our cases as well. While I cannot, of course, for confidentiality reasons, give out any information on it, but we have seen a good few instances of anti-suit injunctions being asked from the tribunal. A couple of them were also ex parte ASI applications, and they have been granted by the tribunal. So I would say the tribunal would look at it favorably as long as the claimant can make the case for it.
Thank you. So far we've looked at the competing concerns that parties and their lawyers might have to keep in mind when they're choosing, for example, the forum where they might want to approach for the grant of ASIs. But what about the tension that might play out between courts at the seat versus courts outside the seat? Especially, for example, courts that might be able to have jurisdiction over matters because of a link to the arbitration agreement. How do you decide which of these courts should have primacy, and are there legitimate grounds on which we're able to build this answer? I think Professor Luke had already touched upon this question in his previous response, so maybe we can start off with him. All right. So what about Mr. Chandu? Yeah.
Hi. Okay. I know all of us have read about this famous case, Vanappa Mittal, right? Which went to Singapore. There's some proceedings in Mumbai as well before the Bombay High Court. Just to give you a very brief of that case, there was this arbitration that was commenced in Singapore, right? And there was also a suit, a proceeding commenced before NCLT in India. And the issue there was oppression mismanagement under the Companies Act in India. So under Indian law, this oppression mismanagement is not something that you can, argue before the arbitral tribunal because it's exclusively the jurisdiction of the NCLT under our legislation here. So this was the argument brought before the courts there to say that you cannot restrain me from proceeding with the NCLT matter because that's exclusive. It's non-arbitrable so far as Indian law is concerned, and Indian law is the governing law of the contract. The matter went before the single judge of the Singapore High Court, and the court decided that while, our Indian law may be the law governing the contract, you've not specified in the agreement what is the law governing the arbitration agreement. An argument was made before the court in Singapore following Enka versus Chubb in England, saying that while you can say so, the agreement itself is governed by Indian law. Arbitration clause is also encompassed in the agreement. Therefore, Indian law is the law you need to look at. Therefore, it's non-arbitrable. Well, you cannot grant an injunction restraining me from proceeding with the NCLT matter. But the court in wisdom, it looked at a lot of case laws around the world, and the High Court decided that since there's no express choice of the arbitration agreement, the law of the seat should be followed. Insofar as Singapore is concerned, Singapore law is concerned, oppression mismanagement is arbitrable. Therefore, it is the arbitral tribunal which is empowered to decide this dispute as well between the parties. So the party who lost the case went on an appeal to the Court of Appeal. In Singapore, the Court of Appeal is the highest court. And the Court of Appeal upheld the High Court order and said that yes, they agreed. Said it is you have to make an express choice, and if you have not made an express choice, then the law of the seat would be followed. Of course, this, if you when it came to India for enforcement, the Bombay High Court refused to enforce it because it said that this will be, see, when ultimately, even assuming an award is given, one of the grounds on which you can refuse enforcement of a foreign arbitral award under Section 48 of our Act is if it's not capable of settlement by arbitration in India. So I think that's what the Singapore courts should have also looked at, is what the Indian courts. This is a very rare case where, though we have very good relationship with Singapore and the courts and the committee and all that, because the party doesn't have any other remedy. How can you oust the jurisdiction of a particular tribunal established under a statute, which even a court cannot do that? So therefore, this is one example which we can look at to see the practical problems of not having law governing the arbitration agreement in your contract. In fact, till this case came, I don't think very rarely people would put in their arbitration clause the law governing the arbitration agreement. You would just say which is the law governing the contract. You would say this is the seat of arbitration. The lex arbitrii would automatically follow, which is the Arbitration Act, and that seat would follow. But there have been instances where there have been problems where, in addition to saying this will be the seat, you choose the Arbitration Act of a particular country. I'm just digressing a bit just to give you an example. There was a very old case, which was the English Court of Appeal case, Union of India versus McDonnell Douglas, where the parties had agreed, for arbitration to be seated in London, but the 1940 Act, the precursor to the 96 Act, which will be the law which the parties have to follow in the conduct of arbitration. So the English courts very smartly, decided, which and I think rightly so, because London is the seat. Therefore, they said the English Arbitration Act will anyway apply. But since the parties have also put in the clause about the Indian Arbitration Act 1940, you will also look at those provisions of the Act like something akin to rules of an institution in addition to the English Act. But these are things the court do to kind of, facilitate a particular factual matrix of a case. Another interesting case like this, Anupam Mittal, of course, in a different context, which arose in Singapore. I was in SIAC then, Steffi. I was the deputy registrar at that time, and I was not involved too much because I was almost on I was leaving SIAC at that time. Alsom, it's the case of Alsom, where the contract provided for ICC arbitration to be administered by SIAC, right? So there was an issue there because how can an ICC arbitration be decided by SIAC? I think that's Manini is a former, it's an alumni of ICC in Hong Kong. No doubt you said Hong Kong as well, very relevant to her. So it came before they commenced arbitration in the ICC in Paris. The other party said, no, you can't do it because it has to be administered by SIAC. They withdrew the application in ICC court, came and filed the notice of arbitration before the SIAC. SIAC took a very broad approach. This was before SIAC had court of arbitration. Now you have a court. A court is not a public court. It's a group of people who decide certain things under the rules. So there was no court of arbitration, but the SIAC took a view. See, parties have agreed that it's going to be SIAC. If we look at ICC rules, for purpose of court, we look at the board of directors and the chairman who will take the decisions on that. The secretariat registrar would do whatever is supposed to be done under the ICC rules. And they kind of said, yeah, we will administer this case. It went before 3 arbitrators, top-notch arbitrators, one Singapore arbitrator, one based in Hong Kong but American, and one Australian arbitrator. Right? It went, the jurisdiction was challenged. The 3 arbitrators upheld jurisdiction. They said, no, we will have jurisdiction. Right? Then that was challenged before the Singapore High Court. A positive decision on jurisdiction. Now even a negative can be challenged in Singapore. It went before the High Court. The Singapore High Court, confirmed the decision of the tribunal. Then the Court of Appeal also confirmed it. Then it went back to the arbitral tribunal. They made an award. Finally, when it went into China for enforcement, the Chinese court did not enforce it. Of course, after that, there's been a lot of water under the bridge. ICC has now specific provisions that except ICC, nobody can administer. It is because of this case, right? In Sigma, was also, I want to look it up. So what I'm saying is these kind of situations are quite rare in terms of which forum you go to. So it's very important for you to get the arbitration. I know I'm moving into your next question, but it kind of relates to this. So very important to draft your arbitration clause properly. Very important when you choose an institution, look at the model clause. Every institution in this website has its model clause. Look at it. If you need to tweak it to your circumstance, you can do that, but don't play around too much with it. Especially qualification of arbitrators, be very careful. Don't put some qualification which you can never get. There have been situations which have been very tough to get, because if you don't have an arbitrator who has the qualification, you can set aside the award. So you need to be very careful when you do this. So I would think that Anupam Mittal is a very good case now, and of course, English Arbitration Act has been now amended in line with the decision of the Singapore courts that if you don't choose the law governing the arbitration agreement, then you would follow the law of the seat. So you need to be very, very careful when you draft clauses.
Thank you. So Professor Luke wants to go now? Yeah, sure.
After that, I have absolutely nothing to say. I think Ganesha has covered it so well. So I have nothing to say.
Thank you. So the Mittal case is interesting to me because I think the problem was that there was an anti-suit injunction sought from the Singaporean courts, which then was sought to be enforced in the Bombay High Court, and they didn't like this because of the arbitrability problem that you've identified. But if we'd had an award, and that was sought to be enforced, it wouldn't be enforced in Australia, in India, because of the arbitrability problem still under the New York Convention. No problem there. It's like, public policy, well, arbitrability, recognised exception. But the award could have been enforced against assets of the award debtor elsewhere around the world. So, for example, if there are assets in Australia, no problem, because we allow arbitrability of shareholder oppression suits. In fact, we led the way, and then the Singapore courts followed in Tomalugan, I think, in the Singapore High Court. So, and so I think it wouldn't have been such a drama, and if we'd had the arbitrators getting their award out more quickly and not stuffing around with anti-suit injunctions, we wouldn't have gotten to this sort of tension between the countries. Now, I don't want to go too much into the moot minefield, but you might be interested. So in Australia, we adopted the revised model law in 2010, and we did some other fixes to the legislation. But Professor Richard Garner from Melbourne Law School and I wrote quite an article published in Singapore, actually, AIOJ, and said, well, here's the top 20 things, not just a few things. And one of them was, there's a gap in the model law regime, as the default law applicable to the arbitration agreement, and it should simply default to the seat. In Australia, it's like, what are you professors talking about? You know nothing. We're just anticipating there's a problem. We know it from the literature, and here's the fix. And of course, after lots of litigation in England and then spreading around the Commonwealth, even England's fixed it, and we haven't in Australia. So we've still got this sort of actually weird regime where the federal court is saying, well, as to whether there's an agreement on this thing called arbitration, that's the lex fori, which will be the Australian law. But as to how to interpret a clause, it goes through the old English pre-Arbitration Act amendment in England approach, and that will mean before you get to the law of the seat, you might, take the law of the main contract that's expressly agreed. And so, I maintain, no, that's far too complicated, and it's an actual bit of a sort of conceptual misconception because, parties choose the main contract governing law for often very specific reasons, bear no relation, to the choice of the seat. And so my view is, as much as possible, things should be, related to arbitration should be focused on the law of the seat. So We did manage to amend the Akika rules in 2016, so that if you, even though the seat was Australia, sorry, if you then you hadn't expressly chosen the law governing arbitration agreement, it would simply default to the seat. But we haven't legislated for that yet, despite my attempts for the last 15 years. But we'll get there now that the English have done it and the Singapore courts have reached that outcome. Thank you.
Sorry, just because Luke mentioned this, I think the De Soto decision of the Supreme Court is actually along these lines of this traditional interpretation of the law of the arbitration agreement being the law of the main contract. And of course, the De Soto of the Indian Supreme Court. And of course it is problematic for the exact reasons that are mentioned, because there are aspects of the arbitration agreement which tie in very well with the law governing the procedure, which is the law of the seat. So ideally we should also sort of be moving in that direction, but I think we're the outliers on this one.
Yeah, thank you. That's a very recent decision, and I think it's made some waves. Steffi, yeah.
Well, nothing on this point. I'm more interested about the next question that we're going to. Yeah.
Thank you. So next question, of course, is about the future, and of course, you should pay more attention to this responses. Mr. Chandru has already alluded to this point. What are the possible ways in which, as future lawyers drafting contracts, how can one think of avoiding parallel proceedings and also think of avoiding, like Manini was mentioning, the anti-suit injunctions and all those battles possible in the context of an international arbitration. So can we start with your points on this?
Thank you.
So I think we already covered it. Ganesh sir said be very careful about the arbitration agreement. Obviously, choose the right institution, choose a supportive institution. An exclusive jurisdiction clauses help, at least with respect to courts. I wonder if a clause for waiver, that by agreeing to arbitration, you are agreeing that you will not present the contractual disputes to court, will be effective. I don't think I've really recommended that before, but I wonder if it will be effective, because if eventually when it goes to court, the court will decide in line with its public policy whether it is restrictive of access to justice. But perhaps that is something that one can think about. I mean, there is obviously a stronger argument for that kind of clause when it comes to investment treaty disputes, because there you could have, a serious multiplicity across jurisdictions and in disputes which actually where the seat is not identified. So that might be an entirely different issue. And you could also have in investment treaty disputes the possibility of two or three different forums to approach. So you have, the agency of the fork in the road clauses and the waiver clauses, etc. But I'm not sure if that works very effectively in commercial arbitration contracts, but I'm happy to be corrected.
Can we have, Steffi, your views on this, drafting an arbitration clause future?
Yes, that's a question I'm very passionate about. That's essentially my bread and butter at this point. Is actually I agree with what Professor Hari said, because this is our audience, right? So the future law firm partners, senior advocates, general counsels would be placed all around the globe. Please make sure that you read and draft the clause very carefully. You know how the arbitration clause is called the midnight clause? Let's, like, the future generation change that, like, let's it not be called the midnight clause anymore. A few technical things that I would mention. See, at the end of the day, even if you have the perfect arbitration clause, if everything's there and if it's all watertight, you can still not stop an opposing party to go and file a parallel proceeding anywhere in the globe, right? But what you can definitely do is make sure that the arbitration clause is not pathological, right? Because ultimately that should not become a battleground as to whether you can go to an SIC or an ICC administered by SIC or an ad hoc clause, or what should be the seat, or what should be the arbitration agreement, because all of these then just delays the entire proceedings. And as lawyers for the claimants here, possibly you would not want to do that. Of course, if you're the opposing side, the respondent side, then go ahead, just keep filing whatever you can in wherever, whichever court you can think of, right? So a few things that you can do to negate the pathology, as Ganesh sir very clearly mentioned, is all the, of course, firstly, institutional over ad hoc. There are so many problems in an ad hoc arbitration. Of course, there are certain places where an ad hoc might work, but if you're talking about international commercial contracts, then definitely institutional is the way to go. And I'm not saying choose as, of course, I'm saying choose SIC, but SIC is not the only option, right? If you have parties from different jurisdictions who might prefer a different institution, please go for it. There are so many good institutions now here, so including the ones in India, right? So definitely choose institutional. Now, once you've chosen an institution, almost every institution would have their model clause. I have just opened the SIC one right here. We have, and it's after the Anupam Mittal case that when we revised our arbitration model clause, we also included that the parties may want to include the law governing the arbitration agreement, because, and I think their predictability is key. That is my advice. Of course, it depends on parties preference, but try and keep the seat and the law of the arbitration agreement and maybe even the law of the contract same if possible, so that that doesn't become a battleground. If at least not the law of the contract, then maybe the law of the seat and the law of the arbitration agreement, and then align it with the institutional rules. Yeah. So that may be the first thing that you should do. And that doesn't even take any effort, right? All you have to do is go and see the institutional model clause and tweak it to the party's preference. The second thing that I would like to mention is also, there are times where you may not know what your parties may wish for when the dispute starts. So there are now, and it's a plug for SIAC, is the new rules that we have now. We have emergency arbitration, we have streamlined procedure, we have early dismissal of claims and defenses, and so many other tools that we have. So when you choose an institution, be very careful to choose an institution that allows for all of these procedures to be used by the parties if and when the situation arises. So I would, so my point is simple. One, choose an institution for international contracts, and second, try and see which institution would serve the purpose the best. Yeah, thank you.
Yes, get on cross, Luke.
Thank you. So I'd like to agree first about the importance of the clearly worded and broadly worded arbitration agreement, right? And that's because if you are applying for an anti-suit injunction, at least in Australia, and I guess in England and so on, that's kind of a threshold issue that you have to have, you have to be able to persuade the court to make this exceptional, well, maybe not exceptional, but just potentially diplomatically sensitive type of order that's going to impact the foreign court. But if you have a clear agreement of the parties, so make that clear. The other aspect is, though, also make sure, if possible, to bring every party into the contract and the arbitration agreement, right? Because I don't want to again step into like the moot problem, but a common scenario is, there is some foreign litigation started by a non-party to the arbitration agreement, and then they apply, so. And you have to try to get the anti-suit injunction to stop that proceeding, but then the problem is that they're not party to the arbitration agreement. But if the arbitration agreement it includes everyone, then you've solved that problem as well. And then the second point about the choosing the rules, you might want to actually write into your arbitration agreement that you want an expedited procedure, for example, even beyond the threshold that's normally applied to put things into the fast track. So what's that now? 10 million Singapore dollars. But you could say, well, no, we always want the expedited track. And why? Well, because then you won't need to stuff around going to any court, because you'll get a sort of the tribunal order for the anti-suit injunction quicker than any court. So you'll solve that problem by drafting an arbitration clause requesting. Now, this may not always work because you may anticipate complex disputes, and the expedite track with large value disputes that are complex might not be appropriate. And then the final point, Malini said, okay, can we solve the problem of parallel litigation by saying in your arbitration clause, adding a sentence saying, we will not engage in any parallel legislation? Well, you're going to have all these problems about what do we mean by parallel legislation, what if the foreign litigation is somewhat different, and but I want to think about what about the opposite type of clause, where you say before you engage in request an anti-suit injunction, you will apply for a stay of proceedings, right? Which before we had anti-suit injunctions, that's all there was. That's the way, and still in many civil law jurisdictions, not all obviously, like Switzerland, France, and so on, but in others, that's the normal way of proceeding. So they don't see the need for an anti-suit injunction because you've got the stay proceeding. But you could put in your clause, you'll at least apply for that. And then when you come, and then if it gets bogged down in the foreign court or it's corrupt or whatever, you've bolstered your chance then for the anti-suit injunction. And who knows, you might solve the problem without going to the extra expense of the anti-suit injunction anyway, because you get your stay. An even more extreme version of this is to say you will wait for the decision of the foreign court on the stay. But maybe that's going too far if there's like extensive delays in the sorts of courts which you might want to, enjoin proceedings in. So those are just some extra ideas.
Thanks, Luke. So that was an academic talking about how to draft an arbitration clause. Now, can we have a lawyer, an arguing counsel view on drafting arbitration clauses?
See, I think we have spoken about institutional arbitration, Steffi has mentioned. One other point I want to actually talk about the SIAC rules and the new rules. Is there something called a streamlined procedure in addition to expedited, which Prof was mentioning, of $10 million. If your amount in dispute is 1 million and below $1 million, then a streamlined procedure will apply under the new Rule 13 of the SIAC rules, SIAC rules, which means whether or not you like it, it will automatically apply unless you make an application and the president of the SIAC courts decides that it will be a normal arbitration and not a streamlined arbitration. So this is extremely good for small value disputes. So if you have an SIAC clause in your contract and it's really kind of, not too complex, the straightforward dispute below $1 million is an extremely, and you'll get an award within 3 months. So that's something I wanted to just point out. Very important, Professor Hari, when we talk about drafting arbitration clauses, we say dispute resolution clauses. You would find in many contracts, especially when you start practice, when you are in joining corporate departments of law firms, you'll have precedents which you will follow, right? Don't blindly copy the precedent and put it, because many of these dispute resolution clauses are multi-tiered clauses. They will say parties are supposed to negotiate. If negotiation fails, then you go for arbitration, either ad hoc or institutional, whatever. But let's forget arbitration for a minute. Talk about this first, first tier. When you go for a negotiation, or it's very vague sometimes. Parties can discuss and decide whether they want to. You must be very clear. It's very important to give a time period there. For example, say try it for 30 days. If not, then you go to arbitration. Then sometimes you have mediation clauses, mediation/conciliation. See, we use Arbitration Conciliation Act in India, but now we have also Mediation Act that has been enacted. Many of those provisions are to be notified, but you can take it that now in India, mediation and conciliation have become synonymous. It's almost one and the same term. And once these provisions are going to be, notified, then that part of the conciliation, which is in our Arbitration Act, is to be read as mediation. So you can use both terms, but the difference that was there earlier is now narrowed and is almost one and the same. So if you have a mediation or a conciliation clause as part of your dispute resolution, then what if one party does not go through the mediation and commences the arbitration immediately? There again, there's a lot of problems. There are case laws which say that you have decided you don't want to opt for that, but you have chosen this. But then there are certain other jurisdictions which say, no, you have to complete that process. So you have to put your mind in drafting the clause, if it's multi-tiered, very, very carefully, and split it, have the first part, then you have the arbitration. Next, institutional arbitration, extremely important, especially since we are all here in India. One of the problems in India is with ad hoc arbitration. While we have excellent arbitrators, in India we have very learned arbitrators, but the thing is, if you don't have an institutional oversight, the main aspect is financial management of the arbitration. You don't want to deal directly with the arbitrator who's going to decide your case as to what your fee is going to be. Of course, we have Schedule 4 in the Act, but many people think Schedule 4 will automatically apply. It won't automatically apply. It is only a kind of a guide given to the court when they appoint an arbitrator under Section 11 of the Act. But practically what's happening in India today is in many of the cases which are not very, very high stake, the parties request the tribunal whether they want to follow Schedule 4. Sometimes the arbitral tribunal themselves follow Schedule 4. When the court appoints, it also says follow Schedule 4. But for these things, I would say you cannot directly go and, it's very embarrassing for you to go and say what is going to be a fees, and the arbitral tribunal says this is my fees, you're not going to be able to negotiate. So when an institution comes, I think in the Indian context, this aspect, if they have an ad valorem fee structure, it's very useful. SIAC has been playing a great part in disputes that emanate from India, but in India, you have homegrown institutions today. For example, you have, the Mumbai Center for International Arbitration headquartered in Bombay. You have the Nani Palkiwala Center in Chennai. You have the International Arbitration Mediation Center headquartered in Hyderabad. There are several other institutions, and you all need to know that by an act of parliament, in India, we have something called the India International Arbitration Center that's been created, and it's headquartered in Delhi. It used to be known as the New Delhi International Arbitration Center. The name was changed as the India International Arbitration. There's an act of parliament which has created this, and it's an institution which is up and running. We have a lot of arbitrators are on the panel. Manini recently got onto the panel as well, and I'm saying this also because I'm also promoted. I'm one of the 3 members appointed by the government of India on this for this arbitral institutions. I'm a part-time member, but this is an institution you can look up to. The aim is for it to become a national arbitral institution. But India is a huge country, right? You have several institutions. Look up the clauses. In fact, Steffi mentioned about this putting in the model clause, the law governing the arbitration agreement. When I drafted the model clause for this institution, this was like 2 years ago. The Anupam Mittal case had come out, so we put it there in that. So if you can look up that model clause there, you will find it as well. So I think important to follow model clause. Multi-tier clause, very important, because I'm telling you, mediation is going to take off in a very, very big way in our country, especially because of recent measures where, high volume, high stake matters of public sector undertakings and government contracts, they are tending not to probably choose arbitration at the moment, which is because of the ad hoc scenario. They should have said we'll choose institutional arbitration. Maybe they will do it in due course, but now they're saying let's try mediation. But mediation fails, you go to litigation, right? Then, there are practical issues with litigation. So you need to look at all this, draft a proper clause. And one more thing I want to, before I finish, if you are going to be practicing in your corporate departments, if you choose a law firm and you're in a corporate department, please send the arbitration clause part of the agreement to your counterparts in the dispute resolution team and ask them to look at it. Because sometimes, though you follow a model clause, the other party wants something and they tweak it. I just saw a clause today somebody sent me where they went and put in a point of the number of years within which you can commence an arbitration. You have to follow the Limitation Act in India. India, the limitation is 3 years. In Singapore, it is 6 years. Right? So you need to look at all that. Therefore, please send it. You need to get a disputes lawyer to look at it. Thank you.
Right, thank you so much. Now we turn to the audience. We have approximately 10, 15 minutes. So you've been listening patiently to fundamental principles and jurisdictional perspectives on anti-suit injunctions. We can take a few questions from the audience, but not on the mode proposition. Are there questions?
That's Thank you for a very good discussion. It was really enlightening. Uh, my question is whether the Indian framework recognizes anti-suit injunctions. We discussed that we have, I mean, we've not enforced an anti-suit injunction in the context of Anupan Mittal because it went against uh, our other laws of arbitrability. But what about anti-suit injunctions? And do we have some parallel process like Section 8 or something? I mean, in any kind of law in India in this context?
It's not exactly anti-suit injunction. Rather, what happens is once an injunction is given, you file an application to kind of set aside that order of an injunction. That's one way, or you appeal. So that's actually the anti. You have to appeal against that order. That's my view. I don't know if.
Uh, I I don't think there is a technical sort of provision which allows that. So Kanishka is right. It would just be the appropriate application requesting the court to exercise jurisdiction. I mean, anti is basically requesting the court of the forum to exercise jurisdiction and to say that any injunction will not hinder the proceedings. And I suppose that is just a routine application that you can also file. I mean, I think in general in international arbitration we have terms which sound very complicated, but they are very simple matters of civil procedure.
Sorry, can I just clarify something though? Like, if you asked for and got an anti-suit injunction and it was disregarded, wouldn't that trigger all sorts of problems, contempt of court, all hell could break loose? Whereas if it's just proceeding with the case, it's like, like that's different, isn't it? That's right. So the nomenclature that what it is that happens could make a difference, wouldn't it?
To my mind, the remedy in India is basically contempt and enforcement. And you would get both the remedy of contempt and an enforcement and execution order to any decree of a civil court. So you're basically looking at filing, you can even file a routine interim application and seek the same relief, to my mind. I mean, I've never done it, but I think that's how it will be done.
Since we've discussed cases of Russia as a sanctioned regime and the English court's decisions, and I mean to ask this without any reference to the mood problem, so what is the situation that occurs when there's such a jurisdictional stalemate where both the tribunal has in its own sense, a valid jurisdiction and the national courts also proclaim their own valid jurisdiction, and both the parties are just left looking at each other? I don't mean like how it plays out legally, but like in the international sense, how is such a stalemate uh, looked upon or worked upon?
I mean, the problem is obviously how compliant a party is required to be of a particular jurisdiction. So if you are a foreign party who has very tenuous links with the court that has issued the anti-suit injunction, you don't have a company there, you don't have a place of residence there, you're not really, there are no major assets that you own in that jurisdiction, then I don't see how a court issuing an anti-suit injunction will have any, I mean, tangible repercussions, you know. So I think at the end of the day, the party, if the question of enforcement is tied with compliance by a party, right? So I think at the end of the day, the party decides what is the more binding court for its own purposes. And I think in most of these anti and anti-anti issues, you will see that it is always the party which has closer links to the court which it approaches, right? So the court ends up issuing the anti-suit injunction with respect to a suit filed by a foreign party in a foreign jurisdiction. So it's just a question of, does that party really have, I mean, if you're doing business in Russia, then of course you have to comply with the Russian court's order. But if you're an entity which wants to sever ties on that business and you really don't have a company in Russia, then you will try and take your remedies in an English court and comply with the orders of the English court. I mean, that's my preliminary sort of thinking of that. So.
So I think it practically happens many a times. You see, I mean, one court grants an order. If you can't enforce it against a particular tribunal, the classic example is an order of an emergency arbitrator, just for purpose of analogy. An emergency arbitrator's order, well, the SIC rules may say or award. In my view, it cannot be an award because you can't enforce it under the New York Convention, right? So you have to bring it. What happens in the Indian context when an emergency arbitrator gives an order, you can't automatically enforce it here. If it's India seated, like in the Amazon case, it was enforced because under Section 17, it is like akin to an order of court. It's seated in India, it's not a problem. It's seated in Singapore, and you have an emergency arbitrator's order, the only option for you to file a Section 9 application here and show that you have got an order in Singapore and ask the court in India to grant such an order. I'm just giving you an example. But what if one party doesn't follow the order? It's very tough, though there are provisions. You can say that even in the Indian Act, we have provisions where you can sanction the other party, something akin to a contempt. But then if they are going to not follow it, it's going to be very tough. But most civil parties will follow it. I mean, I'm not talking about common law as a civil, I'm talking about civil as in society, civil parties, right? Because the reason being, there are certain jurisdictions where there is very dangerous. In fact, there was a very famous SIC, it's in the public domain, so I can talk about it. There was an Indian company which had an issue with an Indonesian bank. They went to Indonesia for negotiations, saying, let's sort it out by way of an arbitration order. But before they could even commence, the promoter of the company was kept under house arrest in Indonesia by the other party. When this is public, so I can it came out in the press in India, it came out in the press in Singapore. I was in SIAC at that time, so otherwise we wouldn't talk about a case which is not in the public domain. But ultimately, they did commence a SIAC arbitration, and they had a fantastic settlement. But I'm saying there are circumstances that I know of, I've heard about, instances where in other countries, I don't want to name them, arbitrators on the eve of the hearing have been kidnapped. This happens. Fortunately, in India, I mean, I would think that while so many people can criticize delays and all that, I think we should be proud about our rule of law, not just in commercial matters and public law matters. Any citizen can go and get a remedy before the High Courts or the Supreme Court under their jurisdiction. You got fantastic. I don't think we have heard such stories in India, but there are. I'm not talking about. I mean, there are jurisdictions where this can happen. Apart from not obeying the orders, you can also resort to all this. So arbitration is also very exciting. So I would suppose that most parties would obey, but you can't do much. You need to find ways in which you get an order from the other. You need to have a lot of other techniques to show so that your the subject matter of the dispute is not gone. Then no point having a fantastic arbitration, right? If the main asset is dissipated, what will you do?
So the pro tip there is that if you're planning not to comply with an order, make sure you don't forget your promoter in that jurisdiction.
I don't know, maybe not a response to your question, but I was thinking about this could be a response to that question, your views on epistemic immunity and the transnational judicial dialogue. So do you think, is there some kind of dialogue, because epistemic immunity, of course, in the context of international arbitration would include judges being arbitrators and arbitrators being counsels, and I mean it's a small community, and there is also a kind of, I believe, a transnational, not a judicial dialogue, but a dialogue between arbitrators and the judges, national court judges. So can this be a response to that question of when parties are left with these two remedies? No, at least in generally talk about epistemic communities in arbitration. Yeah. Right. Any other question from the audience?
Thank you for the discussion. So far we discussed contractual basis for granting ASI, whether there's an arbitration agreement or an exclusive jurisdiction clause. So my question was related to non-contractual basis for ASI, that is, if the foreign proceedings is oppressive or vexatious. So how does, as a practical matter, how does saying that the foreign proceedings is vexatious or oppressive, how does it actually tie generally? Does it hold much water in practice? And what are the grounds to say that the foreign proceedings is vexatious?
My co-panelist pushed the button, so it's like I'm forced. Like, well,
So my question was generally, as a practical matter, how does the courts or the tribunals deal with, say, the party saying that the foreign proceedings is vexatious, even though there's no arbitration agreement per se? There was a recent case where one of the parties to the agreement, instead of suing the another party to the agreement, essentially brought a foreign proceedings against subsidiaries who were not party to the arbitration agreement. In that case, of course, the court can say that this is a collateral attack on the arbitration agreement. So they're not suing the party, but they're suing somebody else who was involved in the performance, and that forms a collateral attack, and therefore the proceedings is vexatious or oppressive. So how does, as a practical matter, how does it actually tie? How much water does these grounds hold by granting ASIs?
Yeah, just in the abstract, and from an Australian perspective. So, our leading High Court, which is like equivalent of the Indian Supreme Court case in CSR in 1997, sort of said that the two bases for issuing an anti-suit injunction are, one, the sort of derived from equitable principles and a contractual base, and the other one is an inherent jurisdiction of the court. And there's big constitutional debate about, you know, which courts have inherent jurisdiction and so on and so forth. But then, in the second scenario, it is to stop multiplicity of proceedings and the integrity of the original proceedings and so on. And so, but the factors, because they come out of a different history and have maybe more of a public law genesis as well, they don't match up completely. So, and some things that could strengthen your case for an anti-suit injunction based on a foreign selection clause, the former equitable-based jurisdiction originally, might not be relevant, in fact, even counterproductive for your argument on the alternative non-contractual base based on inherent jurisdiction. And that's because the focus is different here. The equitable jurisdiction is looking at party autonomy and the parties themselves, whereas the inherent jurisdiction is looking at the impact on the courts. And so the factors can be different. But that's very high level, and if you want to explore it in the Australian context, there's a good article in the I think Melbourne University Law Review 2017 by my former colleague Michael Douglas, not the movie actor. But you'll remember that to look it up. But look, I don't know how that plays out in other jurisdictions like India. I mean, where maybe you've also got these two strands that are trying to come together, perhaps, under this broad rubric of anti-suit injunctions. Just a final point I'd like to add is, sorry, a bit left field, but in the inherent jurisdiction concept, that's where also we get the emergence of anti-arbitration injunctions, right? So you're okay. So that resonates, and this is much more even more problematic for the international arbitration scene. So to go back to where we started, you know, which was anti-suit injunctions can be seen as just an extension and and making more effective the core concept of the New York Convention and so on. So going beyond a stay of proceedings, like preempting having to argue in a foreign court or whatever where there's litigation by stopping the litigation. So it's consistent with arbitration and so on. But an anti-arbitration agreement, by definition, is opposed to arbitration. So you know, unless it involves third parties or something, it's and even then it's quite controversial because of the types of problems you mentioned in practice about, well, are they really third parties or is this just a fabricated third-party intervention to get out of an arbitration, in which case an anti-arbitration injunction is not appropriate. But you know, I think because we've got use, if we look back over 20 years or more, in the common law jurisdiction, we've got, at least in the English context, maybe also in Australia and other countries, maybe less so in Canada, they've got used to the idea of anti-suit injunctions. There's also like a sort of an emergence of, you know, anti-arbitration injunctions. And that's really dangerous for I think, for the arbitration world. And maybe it's another reason to be cautious about anti-suit injunctions, but that's just a speculation.
If I may also. So on your question, I think there are two also tangential discussions that can be brought in. One is you have to, and this is regarding the drafting of an arbitration clause, right? So you mentioned about that case. I'm assuming it's Agiana. If it's not, is that the Supreme Court, the Singapore court case of Agiana versus Gate Gourmet? Okay. So essentially the point is that if you keep your arbitration agreement broad enough to include those third parties in the contract, so, ultimately you cannot stop anyone to go and file a parallel proceeding, right? But you can at least have a stronger argument to state that this falls under the jurisdiction of an arbitral tribunal and the substance should then be adjudicated and decided by a tribunal and not by a parallel forum or a foreign court, right? So the case that I was talking about, the Agiana one, it's simple facts. There were two parallel proceedings, one against the company, the second against the directors of the company. The first, they could have an anti-suit injunction for them because that falls under the arbitration agreement. But for the second, the Singapore court, 90% at Singapore court, I'll have to just come back to you. They did not give an anti-suit injunction because the case against the directors do not fall within the arbitration clause. So how do you normally frame an arbitration clause then becomes important. The second thing also is then the seat also becomes important because when I was researching on this case, I realized that Hong Kong is very active or at least confident in in granting anti-suit injunctions, even if it affects third parties, right? So you'd have to be careful about which seat you'd want to choose. You'd have English, which is a bit more conservative, but Hong Kong and Singapore, which are Singapore limited circumstances, but Hong Kong is a bit more confident and comfortable in granting ASIs against third parties as well. So these are a couple of things that you may want to consider while you're drafting an arbitration clause.
Yeah, maybe we could take one last question. And yeah, here's one.
First of all, good afternoon to everyone, and thank you so much for the discussion. That it was very enlightening. So I have a very basic question that given the varying approaches of every center that's been upcoming for international arbitration, and while considering the future of it, should we also think about something which has an internationally harmonized structure in terms of international arbitration, specifically towards an anti-suit injunctions?
I think it's a very good suggestion. See, arbitral institutions have come together. For example, during COVID, in the pandemic, when we had virtual hearings, they all came up with some common protocols to be followed for virtual hearings. But when it comes to anti-suit injunction, of course, while you can have some kind of discussion or a paper that can be, where arbitral institutions can sit together and do it, this is something which is more in the domain of public courts, right? You're going to the local courts to get an anti-suit injunction. Of course, go to the tribunal, it's a different issue. But going to courts, then I think on anti-suit injunction, each court maybe you can't have something like a model for courts to follow, but these can be discussed for sure in conferences where it has to be actually among judges conferences. It has to be courts like common law courts. We have, IBA, International Bar Association. Then you have International Pacific Bar Association, Inter-Pacific Bar Association, and these associations can take it up and have kind of dialogue between the stakeholders, the practitioners, the judges. See how do we harmonize this? Is there a way in which we can do it? And maybe they can publish a concept paper for people to have as a guide, but you can't force because it's facts and circumstance of each case. That's my view.
So actually, just taking from what Ganesh is saying, because it's a public law issue, that fits well within the context of the access to justice argument. And actually, when you even speak of anti-suit injunctions, which somebody raised earlier, really the argument there in the court of in the local court will be that can that injunction take away from the jurisdiction of this court to provide me relief, number one, and is it infringing on my right as a citizen or as a person resident in this country to access justice? So it's a public law issue which is tied with these basic public law rights, and so that's why there is a difficulty in sort of coming up with an internationally acceptable sort of framework, I think.
I just loop back to the West tankers situation in the EU, right? They were trying to avoid this whole question, they effectively did, and said you can't get an anti-suit injunction from one EU court against another EU court, right? Because of this framework we've got, treaty framework, that there's a code. It's like it sets out the basis for jurisdiction and then enforcement of judgments. And interestingly, in Australia, with New Zealand, we have a treaty as well for recognition of jurisdiction and judgment. So again, no anti-suit injunctions. And so then you might think, well, we've got the Hague Convention on exclusive choice court selection clauses, right? So, but actually, it doesn't. I mean, there's still an exception for public policy there, right? And if one party is saying, well, I fell within that exception, and so I'm going to start litigating there because it's outside the scope of this convention, then you've still got the window into an anti-suit injunction. So you could have a convention where you just don't allow that, but as long as we respect national conceptions of public policy, and we have to make some exceptions for this in the treaty, then we could end up. We're not going to solve in a completely harmonised way.
Thank you. That's an excellent note to end this and wrap up this panel discussion. Maybe have somebody from the audience, from the organizers to deliver the vote of thanks.
Hi everyone, I'm Archie. I'm a member of the Moot Court Society, and it has been an honor to host all of you at our university. And we hope that you have enjoyed the 6th edition of Trilegal International Arbitration Conference 2025 as much as we have. After working tirelessly on this event for the past few months, it has been incredibly rewarding to see it all come together so successfully. I would like to take a moment to recognize the support that has made this conference possible. First and foremost, we extend our deepest gratitude to our title sponsor, TriLegal, whose continued support has been instrumental in sustaining this conference. We are also grateful to our other sponsors, the Singapore International Arbitration Center and Manupatra, for their generous support and association. A heartfelt thank you to our esteemed panelists for leading today's engaging and thought-provoking discussion. We are privileged to have had with us Professor Luke Nottage, who flew all the way from Australia, Mr. Ganesh Chandru, Ms. Manini Barar, and Ms. Steffi Mary, each of whom brought valuable insight and diverse perspectives on the theme of anti-suit injunctions in international commercial arbitration. We would also like to express our appreciation to Professor Hari Shankar and Professor Sahana Ramesh, our moderators for today's discussion.
whose thoughtful facilitation ensured the panel remained dynamic and accessible. I would also like to thank our faculty advisors, Professor Pranav Verma and Dr. Joel Xavier, for all their help and invaluable advice. Additionally, we extend our heartfelt gratitude to our Honorable VC Professor Sudhir Krishnaswamy, who was present here, and our Registrar Professor Dr. Nigam for their guidance and support. Finally, a special thanks to all of our attendees for taking the time to be here and making this event truly special through your active engagement and presence. And we look forward to seeing you in the future editions of this conference. Thank you so much.
I request the participants to be seated. We will be announcing the breaks for the quarterfinals shortly. Uh,